So as the topic goes, we'll be doing a session today on void agreements. So for us to understand, first of all, what is a void agreement? Every time when you just simply do a paper and you take a paper, you put a stamp paper on it, you write something on it, you write the names of the parties, you very well define the entire contract. Is this a valid contract at all points in time? Just because it is signed, just because it has a stamp paper? Not always. Not always. There are various times when just because all formalities are done for, it does not make it a valid contract amongst the parties. So let's see how to, what are the possibilities where the contract can be void or voidable. So coming to the first slide itself, let's understand that all agreements are contracts only if they fulfill certain conditions. So what are these conditions? First of all, there needs to be a free consent of the partner. Like, if I think most of us are aware of the basics of the Contract Act, but still, to set the context right, we look through this once. What is free consent of the parties? What is competency to contract? What is a lawful consideration? What is a lawful object? And specifically, the contract is not of such a nature which is declared void by the act or by the law of the land itself. Now, when we talk about free consent of the parties, free consent means parties have willingly and freely consented to the same thing in the same manner. There is no misrepresentation, there is no fraud, there is no coercion, there is no undue influence. So none of those factors are there. You all have had detailed session, I think, on consent as well. So I'll just mention this here. A free reference to contract is also very important. When we talk about competence of contract, what we mean is that the party needs to be a major. A minor cannot enter into an agreement in India or anywhere rather. Second, thirdly, again, is a lawful consideration. Consideration is very important, and we will look at it once as we move down. Lawful object is again very important. What is the objective? Why are the parties entering into a contract? Now, whenever we do something, each of us always has some kind of an objective, some kind of an aim, some kind of a goal. Like when you go to a restaurant, your object there is not to go and sit on a chair. You want to go and eat the food which is being offered by the restaurant. When you go to watch a movie, you want to watch the movie. Similarly, when we enter into a contract, we have an object. I might have an object to purchase some kind of a garments if I enter a clothes store. I might have an object of purchasing some kind of a shoes some shoes if I enter Bata or if I enter any other shoe store. But my object is not going to be just to go and try. If my object is lawful, yeah. So if my object is lawful, then the agreement and all these conditions are required to be fulfilled. There needs to be free consent, competency to contract, lawful consideration, lawful object. And lastly, the contract or the arrangement is by itself not declared to be void. So we'll be focusing on the last ones today, that there are certain arrangements which are declared under the Indian Contract Act to be void. And what are those arrangements? We'll understand one by one. So we understood how agreements become contracts. And first of all, how agreements also come into places. There is a usual method of there has to be a proposal, there has to be an acceptance, there needs to be consideration, and again, competency of parties is very, very important. Now we come to a very interesting aspect of void agreements versus voidability. Now, when we talk about a void agreement, so the agreement is void, meaning it is void ab initio. It is void from the time it was entered into. There is no question of any party being required to do anything under it. Like suppose there are two people, they agree to XYZ and PQR. They agree to enter into an agreement. They do a very nice detailed deed. How are we going to go and commit a robbery in a bank? Now that agreement is void in itself from the time they started even thinking about it. It is not going to be enforceable because robbery of a bank is definitely not a lawful object. So it will definitely be a void agreement. There is nothing, even if they go and they rob the bank and then one robber says that, Acha, I'm going to take all the money. I am not going to give the other one any share. Can the other robber go and sue in court and say, oh, that robber is not giving me the money? No, that is not possible. That's the concept of a void agreement. It is void ab initio. Now, the other concept which kind of plays sometimes with a void agreement is voidability. When we talk about voidability, so the agreement is voidable or avoidable at the option of at the option of the party which is suffering. Say, suppose I purchased a flat. I really like the flat because there was because there was a particular kind of there were particular interiors done in it. There was a particular kind of a construct of design of that flat. Now, when there is a time lapse between my agreeing to purchase this flat and me actually getting the possession of the flat and me actually executing the sale deed, in that much of time, suppose the seller changes that essential part of the contract. Like he told me that, yeah, this flat, it has a parking below, and I have a clubhouse membership also, and you don't have to pay extra for the clubhouse membership. You don't have to pay for the parking. And by the time I go there, I realize that there is no clubhouse membership, there is no parking, and he has changed the interior of the flat also. So in a way, and actually he didn't have them at all from day one. He was just fraudulently telling me all this to induce me to enter into that contract. Now he showed me some wrong benefits, but it is avoidable. I might still choose to go ahead with the contract because there is nothing wrong. He has the flat in his name. If I choose to still buy the flat in, the flat the way it is, I can still go because there is no prohibition under the law for me to enter into a contract which does not have a clubhouse membership. So it is an option for me. So voidable contract would be something which is like valid, valid, valid. When I choose to call it a void, or when I choose to rescind it, then it becomes a void one. So that's the distinction which we must remember, that there are certain agreements which are like wrong right from the beginning. And that those are the ones on which we are going to focus on, because it's very important to understand where you should not put your time and attention at all. Like suppose tomorrow you get a call and there is a scamster who calls and says that, such and such parcel is coming to your place. It's very common these days, that we know that one of your relatives lives in USA. That person has sent you some parcels, and we are calling from customs, and the parcel contains some illegal things. It contains some narcotics, or it contains something illegal. Now, to get out of this this hassle that you have landed yourself in, the caller tells me that you have to pay me 40,000 rupees. I will send you a proper contract. You sign this, and don't worry, because then you have signed a contract also. No, you have it in your favor, and I'm helping you in this to settle this hassle. So sometimes scamsters can also come up with these kind of things. But this is absolutely a void agreement, because if a person is doing something illegal, he has to pay the consequences for it. He cannot do an agreement for giving a bribe and expect that bribery contract to be enforced under the legal system. The courts are not here for these kind of causes. So that's the concept around which it kind of, the concept of void agreements moves. I hope I made myself clear on that void and voidable. If there's any difficulty, again, we'll, come back to it at the Q&A session. Now, coming to the first aspects that we spoke about was competence of the parties. Competence of parties is very important. Agreement with a minor is always void. So any minor is not supposed to be capable of taking his or her own judgments. So that is why any kind of an agreement with a minor to say, get their share of the property or make them do something. There are multiple judgments on this, and we'll look through some of them later on. Then agreement with a person of unsound mind is always void. So if somebody is staying in a mental asylum and somebody goes and gets a contract signed from him there to get that person's flat transferred in his name, or that person's property transferred in his name, obviously that contract is not going to be enforceable, because that person is of unsound mind. That person cannot take a decision for himself or herself. There should not be any disqualification. And sometimes it happens that when a person is sometimes of a sound mind and sometimes of an unsound mind, like it's defined under section 11 of the Contract Act, usually sound mind and unusually unsound mind. So sometimes in such cases, it could be either ways, like usually sound or usually unsound, sometimes sound, either way. So whenever the person is in sound mind, that time the person can enter into an agreement. Of course, in such cases, it is very tricky and it is very risky also, because you will have to prove whether that person was of sound mind at that point in time or unsound mind at that point in time. So such kind of agreements have their own risks and have their own have their own nuances which will come your way in case you enter into a contract with a person of this nature and which you want to enforce. So such things are there. But anyways, the point that we must remember is that a contract, an agreement with a person of an unsound mind is always void. It will never be considered as a valid contract. Now, capacity to contract, as I said, it has been reiterated multiple times. There were old judgments of Dharmadas Ghosh, Moiri Bibi and all. So recently there was another case of 2015 where somebody did a mortgage, and again they said that the mortgage was for the benefit of the person, but again it was held to be invalid by it's a Supreme Court judgment. So sometimes, in spite of there being clear laws on this subject right from day one, people get into some kind of agreements, and then there are some kind of necessary legal proceedings. So these kind of cases and judgments do come forth. Now we'll move. I'm going kind of in a way where we understand it section wise. So when we talk about void agreements, one essential aspect was competency of contract, which we covered. Now, second, what we have to understand is when there is a mistake. If there's a mistake of an essential fact which relates to the agreement, then that agreement will be a void contract, will be a void agreement, sorry. So how do we find out what is an essential fact is to be determined on a case-to-case basis. Now, suppose I agree to buy I B, and the horse is dead when I and B enter into an agreement with each other. And both cases, naturally, there is no possibility of any agreement. This illustration is there in the Contract Act also. Now, apart from that, if you look at certain other things, now suppose I bought certain rights over a laptop, say a chattel or a movable property, and I was supposed to give it to you. But before I could give it to you, that property got destroyed. I didn't know the property got destroyed at home. So naturally, there is no agreement. Even if I have signed it with you at office, the thing does not exist anymore. So the agreement has to become void in itself. Now, another important section which we must remember is that if somebody is mistaken with respect to a foreign law, that would be a mistake of fact. But if somebody is mistaken with respect to an Indian law, then that is not a mistake of fact. It would be considered as a fraud. Now, suppose in certain territories in India, I am not supposed to sell certain property to you because of certain local regulations there, say some kind of liquors or, not liquor, we could look at any example. Say in Maharashtra, something, there are certain aspects which are governed by the state laws. There are certain aspects which are governed by the central laws. So, we live in a federal structure. So suppose I know that I'm not supposed to do it, but because you're from Gujarat where that was legal, I sell you and you feel that, oh yeah, this is allowed. But, this was an Indian law and you should have also known it. So that's when the mistake of Indian law is not considered as a mistake of fact. And but if it would have been a law which is applicable, say in Nepal or in Bhutan, fact. So when both parties are under a genuine mistake or a mistake, so we were talking about mistake of an essential fact. So when both parties to an agreement are under a mistake as to a matter of fact which is essential to the agreement, then the agreement is again considered. So mistake of an essential fact is always makes the agreement always void, and this is covered under the Indian Contract Act. And we also spoke that any kind of a mistake with respect to a foreign law would be considered as a mistake of fact, but any kind of a mistake with respect to an Indian law will not be considered as a mistake of fact, because Indian law, people are supposed to be aware about that. So that was under section 20 related to mistake. Now we'll move on to unlawful consideration. When we talk about unlawful consideration and unlawful objects. Now, what is an unlawful consideration or an object? It is something when parties are entering into an agreement wherein the objective of the contract is something which is forbidden by law, is of such a nature that if permitted, it would defeat the provisions of any law. It is something which is fraudulent by itself. It is something wherein it is immoral, it is against the public policy, or again, it involves or implies injury to the person or property of another. Now, this is kind of seems to be a very wide section, but this is a very logical and a very general legal principle which anybody can understand, that whenever you do something and whenever you want the court's assistance to enforce it for you, then whatever you are doing needs to be right in its sense. It may be commercially, the consideration may be adequate or inadequate. So I may choose to sell a piece of land for just 10 rupees to somebody wherein the value of land is, say, 10 lakh of rupees. So that is adequacy or inadequacy of consideration. But that is my choice. I may want to do that for my natural love and affection, or I just want to get rid of that property and there's nothing wrong with it. But otherwise, if I'm getting into a contract which is where I'm selling some land to you, wherein that land is reserved for the purposes of garden under the municipality regulations, or I'm entering into a contract with you wherein there is some kind of a for promotion of something which is opposed to public policy. Now, public policy is a very wide term. It's a very interesting term as we move forward in the legal realm, because public policy sometimes also changes with the governments which come and go, and sometimes, of course, but public policy is defined very well under the law, and courts always make it a point to give detailed judgments, or thing, or rationale around it, why something is against public policy. Now there are various things, like every time whenever there's Diwali, firecrackers are bursting firecrackers. Is it against public policy or no? There are two opinions about it. So that is about public policy. But when we talk about agreements, if I'm entering into an agreement with another, and that agreement is fraudulent, or is something wherein the object is something which is forbidden by law, like robbery is forbidden by law, or now robbery, maybe if you consider it to be an ancient example, we look at data theft in today's world, or identity theft in today's world. Now, I am not supposed to impersonate another person while I am giving you my details. So today I am Aarti Banerjee. Can I say tomorrow that I am Preeti Banerjee and I enter into an agreement with another person and say, oh, you know what, I am going to present myself as you while you go and write your, while I will write your law paper for you, and I'll present myself as you. Is that right? That is not going to be right, because whatever is, suppose, some kind of cheating cases, scam cases, all those kind of unlawful things, whenever the objective of the agreement is unlawful, then naturally there is a problem, and the agreement is most likely going to be a void agreement in itself. Sometimes, people try to take advantage that, oh no, the public policy is not like this. No, we meant something else, or, this was not the object. But it is a very tricky sphere. So always make sure that whenever you write the object of the agreement, the whereas clause or the recitals, which set the contract, which set the background, why the agreement is being entered into, is drafted very well, and it is written very nicely what is the actual objective of the parties entering into this contract. Again, consideration is the payment in lieu thereof. So consideration also has to be legal. Now, I cannot get into a contract with somebody and say, Achi, you do this for me. I will give you the money when I go and commit that theft in that office there. After I get the money, we will share it amongst ourselves. So that is an unlawful consideration in itself. So all those kind of things are naturally going to be a void agreement. And again, when I say void, it means it is void ab initio. That means it is going to be something which is void right from the time it was entered into. So that is very important for us to understand. Now, agreements are also void if considerations and objects are unlawful in part. It might be so that, some part of the object is valid, some is not valid. So, some kind of, there is some kind of a mixed arrangement amongst the parties that, I'm supposed to be like this is an illustration again from the act itself. I've taken most illustrations from the act because the act is very comprehensive in itself, the Indian Contract Act, and I really appreciate the way it has been written from the times we've been, using it since 1872, which is like a really wrong time. Now, suppose somebody says that I'm supposed to man a particular traffic signal, and I will say that, yeah, I'm supposed to get the salary of 5,000 for it. I say that, yeah, this is my job, I'll do it. And yes, I will also allow you to take some illegal goods through this place. And while you do that, you pay me additional money for it. Now, yes, I'm doing my duty. I'm doing the job of standing there whole day, manning that whole traffic and manning that whole point or that signal. But and sometime in the night, I allow only one person to pass who has an illegal good. Now, there is part legal and part illegal, but this is again not considered to be valid under the law. Even if there is a unlawfulness in part there, it would be considered as a void agreement. Now we move to another interesting aspect under Section 25 of the Indian Contract Act, where we talk about agreements without consideration. Now, we spoke about consideration, meaning that, there has to be some return obligation from my side. Now, there is no consideration. No, I just agree to go and give you a table tomorrow. There is no consideration. You have not promised to do anything for me. So can you sue me for this, or it's a voluntary effort? It's a voluntary effort. So again, those kind of agreements are not considered to be valid and they would be considered to be void. But of course, there are some exceptions to it. Now, the first natural exception which comes there is a gift. Now, I may decide the concept of gift is very well recognized under the TOPA Act, and there are certain definite, parameters laid down how to make a gift and what to do about gift of an immovable property. Similarly, if I do a gift of a movable property, I decide to gift it to somebody. I decide to gift my particular jewelry to somebody, and I say that, yeah, this is made out of natural love and affection. It is in writing, it is in it is registration if required for a immovable one. So then in such cases it would be valid. I mean, gifts are always considered to be valid if they meet those conditions. Then promise to compensate for something which was done earlier. Like, I had already done a particular job for you, and it's kind of a reciprocal obligation. Now, this is something where parties agree that I decide to do your marketing and you also do my marketing. We will work in alliance with each other. So those kind of agreements would be held valid, though there is no monetary consideration. Because, there is some kind of an exchange amongst them. So there is a promise to compensate for something which is already done, or promise to pay a debt which is barred by limitation law. Now, this is again, I gave money to a particular person on trust, and that person refused to return it, and the limitation passed. So in such cases, then again there is a problem, because I have given the money, but yeah, he said that, yeah, I know, limitation is over, but I will give this money to you because you have already given it to me. Then here again, it's something which is already done by one of the parties. So here it would not be a void agreement, because it's not really without consideration. There is some amount of delay, of course, but it is considered by the courts. Now, we must remember that when we talk about agreement without consideration, it actually refers to something without consideration. Adequacy or inadequacy of consideration is absolutely immaterial here. If the court is not going to sit and weigh that, oh, why did you sell it for 2,000? You could have earned 10 lakhs for it. No, that is not the job. But yeah, it could be a relevant factor for determining whether the consent of the agreement was free or not free. Like, I could say, oh, who in their right mind would agree to sell this invaluable piece of antique furniture to them for just 5,000 rupees? I was not in my right mind. They misrepresented to me. They committed a fraud. They told me they are writing 50,000 on the table, on the paper, but they wrote just 5. And in such cases, we would not be, it would be considered as an inadequate consideration, and it would be a relevant factor, of course. Now, now we come to the contracts wherein wherein some type of contracts are declared. They're declared to be void under the Indian Contract Act. Now, which are the contracts which are declared to be void by the Indian Contract Act? First ones, or, we saw some about mistake, we saw something about consideration. Now, another one under Section 26 specifically speak about an agreement which is in restraint of marriage. Now, what is in restraint of marriage? Sometimes when parties agree that marriage is considered to be, favoring public policy. So sometimes, there are some discussions around it. Marriages, times keep changing. But the section currently says that any agreement which is in restraint of marriage would be considered to be a void agreement. Now, another very interesting part, and something which is very, very well debated at all points in time, is the agreement which is in restraint of trade. This is covered under Section 27 of the Contract Act. And what it says is that whenever there is any agreement which is in restraint of trade, it would be considered as a void agreement. Now, what in so many times we see something which is kind of restraining us from our trade or from our profession. Now, are all of them void, or there is some kind of an exception to it? Now, we must remember that there are some aspects which are always considered when we talk about agreements which are supposed to be in restraint of trade, profession, or employment. We all know that under the Constitution of India, under Article 19, each citizen of India has a right to exercise their freedom of their freedom of trade and profession. So I am entitled to practice what I like. Suppose I'm a lawyer today and tomorrow I am not, I want to continue being a lawyer, but my organization tells me that, you cannot join any other law firm wherever possible. This is a very tricky area which we always come across. So there is a restraint. But if this restraint, is this reasonable or is this unreasonable? Again, what important aspect that we must remember is that when it comes to partners, if there are two partners, they have collectively built the goodwill of a particular enterprise, then there might be reasonable restrictions imposed on that partner, because that partner is kind of leaving, but that goodwill he cannot take with them, and the aspect of goodwill exchange amongst them will have to be decided. When we talk about non-competition clauses, when we talk about non-solicitation clauses, these actually need a different session in themselves, because there's a lot to be spoken about here, because there are always, there are some gray areas where they will be considered valid. Sometimes they're also considered to be invalid. Now, there was a particular case before the Supreme Court long time back, wherein an organization spent a lot of money on a particular employee, Niranjan Gul. The case was named Niranjan Gulkari. So in such case, the employer spent a lot of money, gave particular training to that individual. He was sent out of India. He acquired that special training, and as soon as the training was completed, he chose to leave the company. So then, and he wanted to go and join the competitor. Now, in such cases, what would happen? We would say that, oh, is that really, is it really right on the part of the employee also? Can he claim it to be a restraint on his profession when he willingly and made the company spend money on him? And I think they also told him that, you will have to naturally continue with us for a while. But that didn't happen. So this we have to see. Then again, non-solicitation clauses. It is often considered that in sales departments, there are many times wherein wherein the people working in the department are generally aware of the details of the client. Now, when they leave, will they poach all the clients and go away, or is the client also going with them willingly? So all those things we have to consider. We cannot blindly say that, okay, this is valid and this is invalid. Section 27 specifically needs on restrictive covenants. The general rule remains that any agreement which is in restraint of trade is void. And there are certain exceptions also which we need to see. But the general rule is generally imposed. Now, another important aspect that we need to consider is agreement which is in restraint of a legal proceeding. Now, what is an agreement in restraint of legal proceedings? So this we need to understand. This is covered under, I think, Section 28 of the Indian Contract Act. Now, what happens under these agreements is sometimes parties say that I would not be, I agree that whatever you're telling me is final and binding on me, I will never go to the court. Now, is that going to be valid? Naturally, no. If we have a limitation act under the Indian legal regime. So naturally, if the law allows you to sue them for say 3 years or 5 years or 12 years or 30 years, but there is a limitation of time and the parties say, oh, if you have a problem, you have to go to the court in the next 15 days, else your time is over. Sometimes, it could be a conscious agreement for certain aspects, like a dispute resolution mechanism through arbitration. In arbitration, specifically, parties agree that we decide to oust the jurisdiction of the courts for maybe for certain purposes. Of course, for Section 34, for setting aside the award, we can go to the court. But otherwise, we agree for arbitration as a dispute resolution mechanism. So such kind of a clause is an exception. There we cannot say, oh, no, the arbitration clause is there, so it's an invalid thing. I want to go to the courts only. And, so if you want to go to the courts only, why did you sign up for arbitration? Because arbitration is also a recognized the dispute resolution mechanism under the 1996 Act in India. Before that, there was another legislation which governed it. So we must remember that any agreement which is in restraint of legal proceedings will be held to be void, which kind of ousts the jurisdiction of the courts completely, excepting the arbitrations clauses, and which kind of sets different time limits or extinguishes certain liabilities on expiry of certain periods. So those kind of things are going to be, looked down upon, and it would be a void agreement. Again, sometimes, there is an agreement for the quantification of liquidated damages. I mean, this was a particular case wherein the parties had decided on liquidated damages, and then they decided that yes, this would be it, and we will never challenge it. Now, this kind of language you often see in a contract, that you agree not to go to the court, but this is not going to be valid. Every citizen or every person in India would have a right to avail the legal remedies if he has suffered a proper injury, and if he's willing to, file in the correct court the correct proceedings. So such kind of agreements which restrain a party from going to the court, because the we function in a particular manner in while we talk about governance. So any kind of an agreement which is in restraint of legal proceedings would be considered to be void. Now, another important aspect that we need to look at is agreements which are void for uncertainty. Now, what are uncertain contracts is specifically, I mean, it is generally understood to be by way of wager, which are kind of supposed to be void. So anything which is uncertain in itself, which is, I don't know what's my obligation. I don't know where, what am I supposed to do? Because one party says, oh, tomorrow you come and you give me a car. Now, which car? Which brand, whether working, new car, old car. So there is no clarity what is supposed to be done in such cases. So those kind of hazy agreements where there is a lot of uncertainty, no, neither party is clear what they really agreed on. Those kind of agreements are always held to be void. Agreements by way of wager is also void. So wager means typically, as you can make out, it's a gambling thing. So suppose somebody, now wagering agreements are very important to understand, because by wager, what we mean is that wager is that gambling is the only aspect or the only condition on it. It cannot be that, yeah, you come to my house and, you sell me you've written certain, good articles, or you've written certain good story. So I will purchase the rights on that story from you. And along with selling me that story, we will also play something, and, we'll play a game of cards, and along with that we will see who wins what. So now there are two aspects there. So it's not only condition. So such examples are all such agreements always go on the gray line, because there are two, three things there, and one part is absolutely legal, and the other part is also there is nothing illegal in it. They're not saying that we'll determine it basis that. So that's when the problems arise. That's when, we need to be clear that if we are doing something related to wager, then it would be held void, apart from unless it falls in one of the exceptions. Now, there are certain exceptions also to it, that horse racing is addressed under a different statute, and various other exceptions, but generally wagering, gambling, those kind of agreements, they are void. So when we say that it is void, meaning that it would be void from the time it was entered into. I will not have any rights under the agreement. Now, after we've completed this, what another aspect that we need to see is the impossible acts. This is covered under Section 56 of the Contract Act. When we talk about Section 56 of the Contract Act, what we are talking about is essentially the term became like, a very, very familiar term during lockdown. It is force majeure. So an agreement to do an act impossible in itself is always void. Now, what is impossible is again a question of fact. Sometimes I may say that it is impossible for me to do it, but the other party may very well say that, oh, this is not impossible really, you can very well do it. So commercially unreasonable, is it impossible? Not always. Now, there are two, three aspects which we need to look at it, but let's go step by step. And this is an important aspect again, and this is very, very, this is always a part of dispute, though we always have a force majeure clause and all kind of agreements that you will draft, that you will enter into. Interpretation of that force majeure clause is very important. Now, first understand that an agreement which is impossible in itself. Now, basic ancient examples would be that, I agree to discover treasure for you by magic. So, of course, that is impossible. I cannot do it. I agree to build a staircase from here to moon for you. You pay me 2 lakh rupees. You pay me 2 lakh rupees, but naturally, it's an impossible act. It's a void thing in itself. Now, a contract to do an act which, after the contract is made, becomes impossible, or by reason of some event which I could not prevent becomes unlawful, it becomes void. Now, suppose there was a particular way in which we are transacting with each other. and tomorrow RBI passes a regulation and says that, oh no, you can't transact in this manner anymore. So naturally, after the RBI made it illegal, we cannot do it. So it becomes impossible after that. Till then, whatever was possible, we did it. Now, A and B contract to marry each other, but before the time of fixed for marriage, A goes mad. And here I mean like really mad, not the way we speak in our slang languages that, yeah, I'm crazy today. It's been a bad day. I felt like a mad person. So not like that. I'm talking about somebody who's actually becoming of an unsound mind. So then the contract again becomes void. Now, impossibility is always a matter of fact. This is a very recent judgment which happened, and these kind of things always keep happening when it comes to escalation of prices or commercially becoming impossible. You will see it sometimes through routes or through when the in shipping agreement. So some kind of a channel is closed or some kind of a route is closed. So now I'm supposed to go through another route. Now that route is very much possible. I can very well go through that route, but just that it is commercially more expensive for me. I agreed to take say 10,000 rupees from you because I knew that I can come through a shorter route. Now that route is closed by the government. So now I've come to come through the longer route, and it has become now 15,000 for me. Now I'm not making any profit. So is that bad? Would that be an impossible thing? Or what am I supposed to do? So here, especially when we talk about such scenarios, you must draft your agreements very well. You must draft your agreements in a manner wherein the interpretation of the clause is very clear that what party is determined to be the force majeure or when the parties would be excused from performing their obligations under the agreement. Now here I have given an example of a recent judgment, or it was a power purchase agreement wherein parties were supposed to, one party was supposed to sell power to another, and generation of power was done through coal. So where the coal was supposed to be purchased through another country and the price of coal changed in that country. So there was a change in law abroad. Now again, it was a change in law abroad which led to a commercial impact. It did not make it illegal. You can still buy it. There is no problem. You can continue doing your work. Just that the price, prices keep coming and go up and going down. So those kind of things, when a party wants to take benefit of commercial changes, then it would be a problematic party. It would not be always successful. Now, with that, we come to just last couple of 2 slides on this. We spoke about various things, various void agreements in general. We spoke about contract with minor is void, then unsound mind we spoke about. We spoke about somebody who's incompetent to contract enters into a contract that becomes void. Then we spoke about something which is unlawful object, unlawful consideration, then without consideration, when there is no payment, there's no gift and all that. But, agreement and restraint of legal proceedings, agreements and restraint of marriage, agreements and restraint of trade, wagering agreements, or, something which is uncertain, force majeure. Now, we must remember that every time we enter into this contract, sometimes it is possible that one party, they have already done something, because not everybody knows that this is void when they did it. Now, if they did something and another party gained an advantage out of it, then it is the duty of the party who's getting that undue advantage to return that money to them, or to, they are duty bound to restore the other party. Now, in some cases, you will see that I agreed to sell you a certain antique furniture, and it was there in my home. I took advance also. I took 10,000 rupees advance, and when I came home that evening, I realized, oh, the furniture is damaged. There was some problem and the furniture is already broken down. So naturally, I cannot say, oh, the agreement is now void. So now I'm not going to give you your 10,000 also. That is not the law. What the law says is when there is an undue advantage which is gained by a party because of a void agreement, then you have to go and give that whatever money has been earned, you have to restore it to the other party, because no undue advantage is possible. Now here, if you see an old illustration again, that if I agreed to do a particular job for you and I fell sick when I was supposed to go and sing in that concert, but I had taken some advance. So naturally, while it's a genuine case that, it was not possible for me to sing, I cannot maybe compensate for all the tickets which were sold, but at the same time, I have to give the money back. And for this, it is possible to sue another party to get that restoring. But again, when we talk about this restoring, there are two things, two doctrines which have become very important lately. One is a doctrine of pari delicto, and another one is extirpi causa non oritur actio, which means typically, the concept of void agreements moves a lot around intention. So when two parties are entering into an agreement and they know, I very well know that suppose there is an RFP which is floated by, say, Government of Karnataka, and they have laid down for certain conditions. I know that both of us who are bidding for that particular RFP, we are not eligible for it. We are both at fault. We both know that we are not eligible. This is going to be bad because we don't fall into that criteria at all. But somehow we convey, there is some fraudulent thing which happens, and one party pays money to another to go and pay in that RFP. Knowingly they do that. Now the important word here which you must know is a knowingly. When they enter into something and they want to sue another party for that wrong cause. I know that that both of us are at fault, but still I give you the money. And when I give you the money, it's a wrong thing. Like suppose I know that you're going to go and commit a robbery there. When I know you're going to go and commit a robbery there, I pay you your transport fare. I said, "Acha, you are going there, no? So you take a cab and go. And you will, then because I'm contributing to this, now once you come back with your robbery money, we will share it amongst ourselves." So there is no action which is possible from this, because both parties have knowingly entered into a wrong cause, and in such cases they are not going no law is going to come to favor them. In such cases, it has been held by the Supreme Court that Section 65 is not going to apply. When naturally one party, it talks about restitution when the parties are in the right, when there is naturally some kind of a problem which arose genuinely. Not when two robbers decide something and something goes wrong and they say that no, now you help me. A court is not going to help you do that. So that's the doctrine which comes into picture. And this is very important to understand when you talk about a void agreement and consequences which arise from a void agreement. So void agreement, natural consequences always that, yeah, restitution is there, that, I should put back the party. I should restore them in the position in which they were. But if I'm equally at fault, that's when the intention comes into picture, that when the other party is equally at fault, or when they have knowingly entered into a wrong cause, then no court is going to come to their way.
So the
Yeah.
first question is, what are the things to consider in order to avoid a void contract?
Okay. What is to be considered when we talk about a void contract? Consideration is always what is the object? What is the consideration to be paid amongst the parties? What is the competency of the parties? Are the parties competent? Is the objective lawful, and is the consideration also lawful? So these three things which we have to generally consider apart from the other aspects that we discussed today.
The next question is, what happens to part payments made and later the contract is rendered void? So
Uh,
how does one recover the part payments?
so there again, there are two aspects which we have to consider. One is Section 65, which we spoke about. So any party which has obtained an undue advantage from a void contract, they have to restore it to the other. So this is covered under Section 765. What happens is, if I have taken an advantage, like I said, I gave an example there, that I am supposed to sell a particular furniture to you, and I take 10,000 advance from you. Both of us are unaware that the furniture got destroyed by fire that day. So in such cases, then naturally I have to return the advance back.
Okay.
Hello, good afternoon, ma'am.
Good afternoon, Chandrakant ji. Boliye.
This is Advocate Chaudhary,
Hmm.
practicing in Consumer, DRT, and RERA. My question is,
Hmm.
uh, in the recital,
Hmm.
it is mentioned something, and in after under terms and conditions, something different is mentioned. Suppose,
Hmm.
for example, in recital, it has mentioned that by the plot owner to the this is a development agreement.
Hmm.
If a plot owner is not in the position to develop due to financial constraint, so
Hmm.
he given an offer to develop to the developer. In the development agreement, in the
Hmm.
recital section, it has mentioned the plot owner is not in the position to develop.
Hmm.
So he offering this plot to the developer for the consideration of 50% constructed build-up area. Build-up area it has mentioned, and
Hmm.
later it has stated now this agreement witness and it is hereby agreed by and between the parties hereto as under, and some terms and conditions given, and one term condition, it has mentioned that the developer have agreed that share of the owners and developer, that is 50-50% respectively, shall be calculated and measured from the ground floor to the top floor. Now, the unit build up area or carpet area is not mentioned here, but
Hmm.
the unit is same for both the people. Now
Hmm.
my question is, in this situation, can developer claim that the in the recital it has mentioned that build up area, so the owner should take only build up area? This is my question.
So, what happens in this case, Chandrakant? One is, I don't think the agreement would be declared void in itself. See,
Hmm,
because there is no, there is an uncertainty, or rather, I would not say there's an uncertainty, there's an inconsistency.
hmm,
Both the
hmm,
parties have agreed to one thing in clause 2. I mean, say in recitals, you said they
hmm,
agree to something in recitals, and they say something which is inconsistent in clause 2.2 or in the signature clause or somewhere
hmm.
else. So,
Okay.
so when we talk about this, the only section which can make this agreement to be void is when there is uncertainty. Like
Hmm,
parties are just not sure what they were supposed to do. But I think
hmm,
here the objective of the agreement, that development of the plot, or as you said, it's a development agreement. The
hmm,
objective is legal. The
hmm.
consideration is legal. They are
Hmm.
also very competent to enter into an agreement with each other. But at the same
Yes.
time, they have just made a mistake while drafting couple of clauses.
Hmm, hmm,
This mistake, now we have to decipher the intention of the parties. What
hmm,
was, suppose, there are, if you're talking about a contract in today's times, there
hmm,
would be
hmm.
at least 15 drafts of a development agreement, if not more.
Okay.
So
Hmm,
then in such cases, court is going to sit and actually fathom what was the intention of the parties and what was actually the clause, or whether it was wrongly changed by the developer towards
hmm,
the end.
hmm, 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 hmm.
Like sometimes, that happens, that a final draft is given by one party to another for signature,
Hmm.
and the finally something is changed. So if something is changed finally, then obviously it is on the landowner or the parties who are seeking development to prove it to that nature. And if they are 100% confident that this was not their agreement with the developer, they will, if they search, they will find enough material for against the developer.
Yes, yes, yes. But the thing is that
Hmm.
this division of share is mentioned in three more clauses
Hmm.
after the heading that this agreement witness and it is hereby agreed by the between parties, and wherein no unit, either
Hmm.
carpet or build-up is mentioned, but both the parties will get 50-50% share in the developed building. So, in this scenario, is it possible for the developer to claim that the owner should get only build-up area? Is it possible?
It is mentioned, you say the reference of built-up areas only in the recital, no?
Yeah, it is in the recital, but later on the terms and conditions were
Are
uh,
different.
huh,
No, see, what happens, Chandrakant, is recital does not have any over importance in the agreement.
okay,
We cannot say that something is there in the recital, so it is more important than what is stated in the clause.
okay.
Both
Because
are on equal footing.
yes, because clause have agreed, accepted, and recorded in the
Yeah.
agreement.
So builder cannot, I mean, I don't think his contention will find favor with the court, because
Okay.
court is going to look at the entire agreement as a whole. They will not
Hmm.
say that recital is more important than schedule, or schedule is more important than clause 2.5 or anything of that nature.
Yes, yes, yes. And another point, what you have said about the
Hmm.
arbitration clause.
Yeah.
Nowadays, builders are
Hmm.
fraudulently including this one paragraph of the arbitration to ask the
Hmm.
jurisdiction of the civil court
Hmm.
to take the advantage over that. But
Hmm.
nowadays, consumer court is of helpful to the flat owners or buyer,
Yeah.
and this despite of this clause of the arbitration, the this case is maintainable in the consumer court. Thanks a
Hmm.
lot.
Hmm. Okay.
Thanks a lot.
Thank you so much. Yeah, because consumer court is always a special remedy. And if a
Yes,
consumer is suffering, then the Consumer Protection Act is going to come to their rescue. And a lot of time courts have taken a very pro-consumer view also.
yes, yes, yes.
And sometimes, yes, I mean, the builder has put that clause in, but I would say that, by the time parties or litigants come to the court, they have already signed the agreement. If they come
Correct.
before, then it is always possible that, you check the agreement there and then, you don't have to, even if the builder is not going to change it, at least some common, points like what you mentioned, inconsistencies can very much be removed because
Okay.
otherwise it's a very long litigation.
Yes, 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 yes.
Yeah.
Thanks.
Yeah.
Thanks a lot.
Thank you. Thank
Okay.
you for your
Thank you.
query.
Thank you.
Yes.
Next participant.
Good afternoon, ma'am.
Good afternoon.
Thank you very much for this informative session.
Yes, sir.
I have two questions. One is, what is the difference between void and unenforceable agreements?
Hmm.
For example, if at all there is a sale of land where it has to
Hmm.
be compulsorily registered
Hmm.
under Registration Act 1908 if the value of the asset is above 100 rupees.
Hmm.
The parties enter into agreement and they have not registered it. Then
Hmm.
what are the rights of the legal heirs of the parties if the agreement has been executed 40 years back and
Hmm.
none of the parties are alive, but
Hmm.
the purchaser, the legal heirs of the purchasers want to enforce it in the court of law? What is the remedy for them?
Okay, so we'll look at this first, then we'll go to your second question. So see, when there are certain formalities to be done and such, if non-adherence to those regulations or to those formalities is not done, there are two aspects. One is if registration is mandatory and registration is not done, that sale itself is void ab initio. That means that suppose I am supposed to sell a property, to sell my flat or sell my bungalow to another person, and I do it on a plain paper. I don't pay the stamp duty, I don't register it. Naturally, that sale has no effect. So it is void ab initio. But your question is very pertinent because if it's a void agreement and knowingly I know that this is a void agreement and I have taken that money from them, I have taken 2 lakhs from them. So naturally, I have to give that money back to them. But here there are two things which you have to remember, and that's when the last two sections again I will have to go back to, which is section 65 of the Contract Act, which says that if any party draws an undue advantage under a void agreement, then that undue advantage has to be restored to the other party. So if I have drawn an undue advantage from the other party, then I have to give it back to them. But there are two things. Enforceability of that agreement will depend upon the intention also. Now, if both parties knowingly, both parties know that registration is mandatory, still I gave you that money, then naturally no court is likely to come to help you. Because in such cases, both of you are trying to play, I mean, it was just maybe a prank amongst yourselves or God knows what was it, but a court is not going to spend its time on it. So that is when the parties are held to be equally at fault. And the possibility of enforcing it is very, very bleak. But and here you have to enforce, like here you have to see what was the intention of the parties. Did they know it? Did they know that it was illegal to do this kind of a contract? Did one party know, the other party didn't know? So all those aspects come into consideration.
But
And
it
I
is
see
very
you
difficult. Sorry, but it is very
sorry.
difficult to prove the intention of the
It
parties.
is very difficult. It is
Yeah,
very difficult. And in fact, if you're talking about something which has happened 40 years ago, it is,
yeah.
and they have not done anything till now, you have to prove, I mean, forget intention. The first fact of payment only, how will you prove? Was there any exchange of consideration for that car in the first place?
Yeah, there was an agreement on a stamp paper, but which was not eventually registered.
Huh.
But the amount and all things are mentioned. The second point which I want to make is, say for example, if the property is developed and if the buyers, the sellers, legal heirs,
Huh.
they take some share from the developer,
Hmm.
can these purchasers say that now this is the undue advantage, please share me whatever he has got? Or will he get the amount only? Say, for example, if it is 50,000 in 40 years back,
Hmm.
will the court say that, okay, 50,000 again with the indexation of inflation, you take it? Or is it that, okay, if he has given you 100 square feet, please give 50 square feet to the purchasers, those who are not registered? How do you quantify it? How do you quantify the damages?
The section typically speaks about undue advantage, which and restoration. So whatever you gave, that definitely you are entitled to. Now,
Okay.
if from a void agreement, which is void ab initio, like, see, we have
Okay.
to understand one thing, that this is void from the time it was made. It is not
Okay.
voidable. It is not something which is, which was valid till the time I chose to rescind from it. So,
Okay.
so that's why the possibility of, gaining an advantage of a 40-year-old contract because of inflation and because of indexation, that is going to be very, very difficult. Because
Okay.
see, and where was the possession of the property is also very important. Like, I gave money, so did I get the possession, or they did not give the possession because it was a void agreement?
Okay.
There are many
So,
things, I mean, were you enjoying the property for so long? If you were enjoying the property for so long, then they cannot come and complain now that it is a void
exactly.
thing, because I gave you money, you gave me the property, and
Okay.
we continued under this, and we were
So,
both equally at fault.
so is it such that if the purchaser had the possession, he would have a better case in his hand?
Maybe
Because
if
it,
you would have had the possession, there were many things which could have been better. I mean, it would have actually then many things at least you would not have to prove. Then
yeah,
you would not
exactly.
have,
That,
yeah, you would
yes,
not
yes,
have to
yes.
prove that I have paid. You would not have to prove that there was an agreement. So at least,
Okay.
it would, because the parties have acted on that agreement itself. No.
Okay. So there is
Yeah.
no sort of remedy available for the purchasers in this case.
Actually, the purchaser are not in possession in this case.
Yeah, exactly.
See, if the purchaser is not in possession, the purchaser gave money some 40
and
years
and
back.
and there are follow-up agreements based on this basic agreement
Hmm.
where people have said that okay, I will take some X% of this and that. So now, and especially this piece of land is in Mumbai itself.
Yeah.
Uh, so now the stakes are too high, and everybody wants their pie of out of it.
Sometimes, if we have
I
to
mean,
see actually the papers and then come to a
yeah,
conclusion,
yeah.
because it is
It is
difficult for
only
me to
thing
tell
is
you.
that if at all there's a slightest chance of any litigation, then they can come to commercial settlement. Otherwise, it is very difficult, as you said, if it is void ab initio.
Because it was, see, because if the court permits an agreement which is not,
Exactly.
if it defeats the provisions of the law, no?
Exactly. Exactly.
That's the difficulty when we look at the agreements. And sometimes I think knowingly also parties enter into these things, and when they realize, oh, there's too much advantage. So,
Yeah.
let's say that, oh, I was fooled, or, there was a misrepresentation. But
No. Yes, the ignorance of law is no excuse.
ignorance of law is no excuse unless and until it's a foreign law again. If it's a
Yeah,
foreign
yeah,
law, we
yes,
can
yes,
consider it. But
yes, yes.
otherwise, my best wishes for you and them.
Okay, thank you, man. Thanks a lot. Thanks a lot.
Thank you, sir.
Ma'am,
Yes, Yesha.
so my question was, now prenup agreements
Hmm?
are not legal.
Prenuptial agreement, Aarti.
Yes, tell me prenatal.
Prenuptial, the ones that you
Prenuptial
enter
agreements.
before a wedding.
Prenuptial agreements. Yes.
They're not exactly legal in India,
Hmm.
but can they still be enforceable in the court of?
See, prenuptial agreement and enforceability will depend on what is written in it, really. We cannot say, because see, the name of the agreement, Yesha, has very little relevance and importance when you talk about enforceability. Enforceability of an agreement in India depends on various factors. What is the objective of the agreement? Are they settling down some terms there that, okay, we agree that we will continue to stay in Delhi? Or are they agreeing on certain other aspects? And when we talk about prenuptial agreements, the public policy aspect comes into picture. So what is actually written in the agreement? And unless and until it is something which is against the public policy of India, there is no harm in it. But again, I would not be able to comment very clearly till the time we see what is there in it, because a prenuptial agreement does not suffer from any illegality by the name itself. It's not in restraint of marriage. So if it's an agreement which restrains a party from marriage, then it would be a problem. Otherwise, it's okay, and it does not restrain anybody from legal proceedings or anything like that. There is unlikely to be an unlawful consideration for it. So what is written inside would make a difference.
Okay, thank you, ma'am.
Aarti, last question for the day. Pradeep sir is
Okay.
asking on the chat box if the subsequent clause is contrary to the main clause, what
Hmm.
will supersede? Will it have an overriding effect? And if yes, what is the legal remedy?
Can a subsequent clause, a contract clause which is contrary to the main contract overrides or supersede, and what is the remedy? No. See, just because the order of the clauses does not make a big difference to the enforceable, when we talk about enforceability value in itself. And unless and until it is specifically mentioned that this is supposed to override, supersede any inconsistency or in contrary provisions, this is not going to happen. And second aspect which we must remember is, if when sometimes we enter into addendums. So I may do an agreement today, and then tomorrow or maybe 2 years down the line, I enter into an addendum, which is a modification of the original agreement. And the whole objective of that addendum is to modify the document. So such cases, naturally, the subsequent clause, which is subsequent as in the clause which is mentioned in the addendum, is going to override, and it is written so in the addendum that this clause will override the original written clause. Sometimes in agreements itself, we talk about notwithstanding provisions. So the clause will say notwithstanding clause 6.2 above, or notwithstanding any other provision of this agreement, this provision will prevail. So that, unless and until that is written, it is difficult to enforce. And I think the key to your contract, I mean, you said what is the remedy? So the remedy is to make sure that to take utmost precautions while writing the agreement itself. We are all aware of the time it takes to enforce an agreement today in India. It's really, really very long. And why burden the judiciary? Why burden the parties with an unnecessary litigation? Make the contract which is consistent, make the contract wherein each provision is read carefully and is not so that, it is contradictory to something which is stated on page 1, page 2, page 3, like that. So the remedy is to enter into a proper contract. But if you are stuck with a contract which is having inconsistencies in itself, there is no priority. You will have to actually, the court is going to decipher the intention of the parties and determine what was their real intention, which I don't think so will be a very short process.
Thank you so much for such a wonderful session. It was quite engaging and very informative. Thank you.
Thank you so much, Malvika. Thank you to all the participants. I hope you all enjoyed.